Amen. So I want to invite everyone who has joined this meeting, members of the LSK. On call are also judiciary staff members who have joined this platform so that we can all be trained together. We can all know and appreciate the challenges that we are facing together and then wage a way forward together. So I want to sincerely thank you, and I want to invite you for this training. I will be making very few remarks, and then I will invite the chair, Mr. Nyabena, to make his remarks. And then I want us to spend a lot of time just on the consolidated court fee schedule, knowing all about it, and we can now have a demonstration done. And then we also spent quite some time on question and answer, because there are a number of challenges that all of us are facing with the configuration of this court fee schedule into the our e-filing system, our case tracking system, which is an internal system. So we all know that the judiciary
Honorable Tanui faced some challenges. She's going to be back soon. Sorry for that.
Thank you. I'm sorry I disappeared. Can I be heard now?
Yes, we can hear you.
Thank you. Thank you. So what I was saying is that we all know that the judiciary does receive revenue on behalf of the government, comprising of, among other things, the court fees. So, and in respect to court fees, we are aware that they were all over, as in various schedules, in various scattered legislation. And I was using the example of the Children's Act, where we have a schedule there, which then determines how we were supposed to pay court fees and which documents attracted which kind of fee. So different court fees. When you come to the Income Tax Act, it has its own schedule and the documents that are supposed to be filed in court. So it became a bit messy, it became a bit confusing, where you would go to one court and you get that one court is charging different fees from the other court. So the Chief Registrar of the Judiciary then constituted a court fee assessment committee to review all the existing legal framework and make recommendations to ensure effective and efficient collection of revenues. That committee was headed by Honorable Omange, who is will be joining us later. She was in the launch committee, the launch where the Chief Justice has been launching her vision. So she's supposed to have come and be part of this meeting. We are hoping that she will join us even as we proceed. So the development of this new fee schedule now went through an extensive stakeholder consultative process. The key stakeholders that were engaged included you, the LSK members, the court users committee, even us internally, the judiciary staff and officers. We were all engaged before this new fee schedule was finally advertised, and the members of the public were called upon to make comments about it on 14th of August 2020. Thereafter, it was now placed before the Chief Justice for purposes of gazetting the same. So on 1st of July, on 9th of July, the Chief Justice did gazette that new court fee schedule. It took us 2 months as a judiciary to have it configured into the system. And on 1st of September, we know that we went live with the same. And it is now what is currently in place. We are using it to charge our court fees. A lot of challenges have been experienced, and we will be discussing why those challenges and the way forward in respect to those challenges. But for now, let me just talk about 3 things that have changed. We know that now there is a shift completely about how we were charging fees before and here now. One of the things that have changed, and I will use an example of a plaint. If you were to bring to us a unliquidated plaint, for instance, a plaint whose claim is unliquidated, what I would do, what my colleagues would do in the judiciary would be to look at that claim and consider the nature of it. So we would look at the nature of the claim that you're bringing. We would also count the number of prayers that you're claiming. And then we would multiply the figure that is given. For instance, if you wanted an injunction or a declaration, we would multiply the number of prayers by a figure of 1,500, at least in the High Court. So that if you had 4 prayers, you want a declaration, you want an injunction, you want a cancellation, for instance, in the Environment and Land Court, you would be charging about 4,500 for that particular claim. But what has now changed is that once you bring an unliquidated claim to the High Court or even courts of equal status, it is a standard figure of 2,000 shillings. So we have moved from looking at the players to just having a standardized figure across courts and across divisions for that particular claim. And for this instance, I have used an unliquidated claim. The other thing that has changed is that we are not charging fees as per the document that you bring. Before you would bring a plaint, you would bring a verifying affidavit, a summon. Each of those documents would then attract a different kind of fee. What has now changed is that a plaint is the primary document. And out of a plaint is born many other pleadings. A plaint gives birth to a verifying affidavit. It does give birth to lists of witnesses, witness statements, list of documents, bundle of documents, submissions. So once you pay the 2,000, which I have used before, it takes care of that plaint for its lifetime. The only other time that you will need to pay if you are the plaintiff is when you are applying, you are making an application, either one to add a party or you want to amend. So for any other application that you are making, then you will pay a constant figure of 1,500. And I'm using the High Court in this sense. So, and then for that particular plaint also, an application, the application will take care of the application itself, the affidavit in support thereof, and every other annexure and submissions in support of that application. So for every primary document that you pay for, it takes care of all the documents that will come out of that primary document. So that is one of the things that has also changed. The other thing that has changed is that many of those fees that we were charging have been dropped so that you have a number of documents which you can either file free or you can get free from the judiciary. I have talked about the children's court. All the services in the children's court will now be, has been zero rated. We talk about, for instance, certification now, and perusals, they will not be charged. So those are the things that we will have to learn how to go, especially for us internally, that we will then give you an opportunity to peruse documents. We will give you an opportunity to have certified copies without asking you to make payments. So with those few remarks, I want to invite the chair of LSK, Mr. Nyabena, to make his remarks, and then we will now go into the meat of this training session. Karibu sana. Chair.
Thank you very much. I wanted to use my other device. Just a minute. Thank you very much for this opportunity, Honorable Tanui. It's an occasion that we were looking forward to. First, you remember we are the ones who said roll out this filing fees, but there are several challenges that have come in by virtue of the implementation. You have made a very good presentation, which is very clear that once I pay for my plaint, I'm not supposed to file for documents, witness statements. But most members will tell you today that the position on the ground is very different. We are used to a situation where I think is a judiciary staff in the registry who believe that every document that you present has to be paid for. So if somebody had paid for a plaint initially and now is filing an affidavit, a list of witnesses and the rest, there is a lot of confusion. There are instances where people have been asked to pay 1,500 for a witness statement, for an affidavit of service. And as branch chairs and leaders, we have been called upon then to try and intervene on these issues. Maybe you need to do a directive to the effect that there should be no charging of fees in respect of submissions where a plaint has been filed, in respect of affidavit of service, and in respect of questionnaires. In some instances, when I present my plaint, I may not have presented all my witnesses, and along the way, I have to file those witness statements. Ideally, my understanding and the trainings that you've given us indicate that in such a scenario, then we should not be charged any fees. But this situation is very different. There is a lot of outcry that the judiciary wants to make more money than it ought to. Assuming somebody comes to Mombasa Law Courts, he has a list of documents, he has a witness statement. When a clerk assesses that to be 1,000 or 1,500 each, you see they're already paying 3,000, which is very difficult. I'm minded that Section 96 of the Civil Procedure Act makes provision for a litigant making up for deficiency of court fees. If I pay less, the judicial officer along the way can make an order that I pay more. Sadly, this law is silent or does not cater for a situation where I pay more. Am I likely to get a refund? I think that is a question that the judiciary needs to answer. And if then it is difficult to get a refund, we should have a scenario where a dispute can arise as to the filing fees so that I pay the lesser sum, because then the judiciary will be able to, if I'm shown to be required to pay more fees, then I can top it up. But once a litigant has paid more fees, currently there is no possibility that they will refund. Some of these cases are filed on a day, maybe it's the last day of filing. So we really need to deal with such issues today. And then this generally, we do not need to increase the fees astronomically. My understanding also, which should be reiterated, is that once are paid for a plaint, unless I'm filing an application, I'm not supposed to pay any more fees. Or if it's otherwise, we should be able to be told. So there is a lot of confusion now. And I think in our view, the judiciary has been very slow. If I remember very well, the first gazettement of these fees was actually by the retired Justice Emeritus Maraga, who did a gazette the fees. I think it's in October or November. You will see the notice by Honorable CJ Kome revokes that notice. So the judiciary has been a bit slow, and the judiciary needs to disabuse this notion that it is out to get fees from litigants. So we really need to have a honest conversation today, and I look forward to that confirmation, and if necessary, a circular emanating from whoever is in charge of fees, either the CRJ or yourself, to be able to tell Kenyans clearly and litigants clearly that in these instances, you should not pay fees. You remember in the court fees schedule that was repealed, there was a provision that for filing any other document otherwise not provided for, and the fees that had been set then for such a document was Kenya shillings 75. As opposed to that previous schedule on charging court fees, the current one doesn't have that default. And at times now, it's really unrealistic to expect people to be paying 1,000, 1,500, maybe because I'm filing a further affidavit. If I had filed a replying affidavit, I'm now filing a further affidavit, and the schedule talks about that is just opposing the application, then I should just take my affidavit and stamp to court. It's not my day to say much, it's a day for members. So allow me to return it back to you, Honorable Tanui.
Thank you, Chair. All those concerns have been noted. We should be able to answer and wage a way forward together. So without much ado, I want to invite our Director of ICT, Mr. Karanja. Mr. Karanja will give his remarks and then invite the team that is dealing with our training. Then we will come with the question and answer session later. Mr. Karanja. Mr. Karanja, are you there? In two ways. One, we will have a run through the court fee schedule, a very fast run through, and then we will have a demo now of how we are charging fees, which will inform the many challenges that we are going through, and will also inform the question and answer session. So I will invite Mr. Tuya. Mr. Tuya, please come on board.
Honorable Tanui.
Are you here, Mr. Karanja? Thank you.
I couldn't unmute my mic. So
Asante. Karibu.
Okay, but I'm here.
Karibu.
Thank you, Honorable Tanui, and thank you, Chair, for this opportunity, and members of LSK. We are glad that as we committed, all of us some time back, that we'll be having these regular meetings until we are all ideally on the same page. So mine, again, is to just focus on what the Chair has said, and also Honorable Tanui, that these changes to the fees schedule, as we discussed last time, the last time we had this meeting, we were promising to roll out from the 1st of September. It's been 16 days of intense work for us in learnings. And I want to thank the members for standing with us, giving us feedback. both negative and positive, so that we've been able to improve the process. As Honorable Tanui and the chair have noted, there is a drastic change in the way court fees are handled in the courtroom, and that has an impact on the way also the e-filing and the internally fees are assessed. And I want to acknowledge that it has not been a smooth ride because of the drastic nature of the changes. So we've had some teething problems, both from the system-wise, and also from, as noted by the chair, which is why we are here, the issue of stakeholder engagement, both internally. We've had very many sessions with our internal stakeholders. Just all of us be on the same page, because we have to have a paradigm shift on the way we handle fees, whether you are the advocate or the clerks we send to our court station, or the clerks they find from our side. So I will not say much, just to promise we'll continue enhancing the system, we'll continue improving. Because of the many changes in the last 16 days, there has been some destabilization of the stability on the system, but we are working very hard on that. Two, I want to really reiterate that we had shared a link for virtual support, and we are trying to try as much as possible to make sure that support is provided besides the normal way of calling phones. So we just try to see if it can be, we can make it as smooth as possible for the team. I want to still promise from my directorate, we are working very hard. In fact, the team works 24 hours. Just make sure that the system is configured to give you what is in the Gazette notice. As Honorable Tanui had mentioned some time back, there are some gaps we are noting in either in the court fees or in what we have been filing, or some documents are missing. But I promise you, we will continue, and we'll see today there will be an improvement from the other trainings we have done, especially in handling of documents which are either not listed in the schedule or which have come up since we did the implementation. So I will now want to call my colleague, Mr. Atuya, who will take us through the schedule, and then after that we will now show you how we have done the actual implementation and the improvements that we continue to make. Thank you. And I will really appreciate if you have any query, just continue putting it on the chat so that we can collect that together with the Secretariat, and then we'll address them as they come. Thank you. And so I will invite Mr. Atuya.
Thanks, Mr. Karanja. Thanks, Honorable Tanui. Thanks, Chair Nyabena. And welcome all the LSK members, our advocates. We are happy to have you, to meet you virtually. And we'll also be happy to get a feedback on the user experience, especially on the new fees and the e-filing. So once again, we will really appreciate your feedback through the chats as maybe I proceed with the presentation. I hope I'm audible. My name is Geoffrey Atuya, a system analyst at the Directorate of ICT, and I will be taking through an overview of the gazetted court fees and on how we have configured it in the system. Maybe Mr. Karanja can confirm whether I'm audible, then I will be able to present. Or I'm muted. Mr. Karanja, am I audible?
Yes, you are audible. We can hear you.
Yes, thank you. Yes, I want to make highlights on the new court fees, what we have done in the system, so that I build a foundation. Once we go now to the system, you will see what we have done in the system. I want to share my screen. So I want to share my screen. Yes, I hope now my screen is also visible. I want to give aspects that the new court fees that we have configured to the system. One, the court fees, we have done what we call exploiting the aspect of standardization. Just standardization, that the court fees have been standardized across various court ranks and court levels. I'll just highlight one of it. Maybe if you see number 9 is bill of costs. Bill of cost is 500 for the I codes, for the I codes, ELC, magistrate codes, and magistrate codes. So you see this has been standardized across. So that's an aspect that I'm bringing in. So in the system, I want to see even it has been easier for us to configure. Bill of cost has been standardized across I codes, ELC, and the lower courts, 500. But in the tribunals, it is different. Response to bill of cost, so it's 500 all over. So it has made even the court fees predictable. So one is standardization. So we have standardized bill of costs. We have also, there's also the aspect of standardization of application, filing any type of application. It's also 1,500 across I courts, ELC, and for the magistrate court is 1,000. So, but it has been standardized across I court and the courts of equal status. So, maybe I can, before I move to these aspects, so the gazetted court fees, which were gazetted on 19th July, brings in the aspect of standardization of court fees, brings in the aspect of simplification of court fees. So among to those will be my thematic areas. I'm going to look at how they have been standardized, how they have been simplified, and also the aspect of consolidation, or sometimes what we call bundling of fees. So those are the three global areas that I'm going to touch on, so that we can be able to move to the practicals. One, let me maybe start with the bundling or consolidation of fees. In the previous regime, we used to have one-to-one fee assessments. That is, one fee, one document. Let's say 75 shillings for an affidavit, 10 bob for an extra. Now that has been, we are moving from there. Now those have been bundled together. Like now say, or the, like now if you see my number one, all the from A to J have been bundled into one, and they would have a one fee. Unlike before, a plain would have its fee, verifying affidavit would have its fee. So all this has been bundled. That's why we are saying there has been an aspect of bundling. So I want to see in the system, when we are talking about these documents have been bundled, and then we have what you call the mandatory documents, or what the term use, the primary documents and the secondary documents. So that's what. So the bundling is affecting is across high courts, lower courts, and the courts of equal status. I want now to illustrate the aspect of simplification. How the aspect of simplification has come in bundling. Now, let's say someone is filing a claim of say of a random figure, let's say of 50,000. So once someone is filing a claim of 50,000, that claim will come with a bundle of documents. That's those that are listed here. So once there's now a schedule for assessing of that claim. Yes, now this is a schedule that we have built into the system. If someone is having a claim of, let's say, 500,000, you will pay a one-off fee of 10,000. So you can see that the fee is predictable. You can be able, even for as an advocate from your office, you will be able to see how much you are able to pay even before engaging the system. Maybe you are preparing a plaint that is liquidated, and you know my claim is 1 million. So you know if it's 1 million, you pay 10,000. So you know. That's the plaint. So all the secondary documents now accompanying the plaint will be deemed paid for. So This aspect would ensure that what one court station is charging is uniform across all court stations. Unlike before, when we were using a formula, some people were counting prayers, other people were counting other things. Now it's simplified. As an advocate in your office, when you have prepared your documents, you are able to know from the word go. Even those now, the clerks at the advocate's office, it's even easier for them. You are able to know how much you're going to give the clerk to go and file. It's not now complicated that we have how many pages of annexures. Now it's that simple. You have 1 million, there's this schedule. You are able to know if it's a plaint, this how much we are required to pay, and it caters for the accompanying documents. Now, if it's for unliquidated claim you are preparing, it's even much simpler. It's just 2,000 if it's unliquidated, whereby you don't know the exact sum that should be paid. Like now, if it's an unliquidated claim for both high courts and lower courts, we have configured you pay 2,000 for the accompanying document. That's for the plaint itself, verifying affidavit, summons, list of witnesses, statement documents. So you can see it's predictable. You would now be able to manage even the law clerks, and the clerks at the law firms. If your plaint is unliquidated, it's just 2,000. Save for if your annexures are not exceeding 100 pages. So so it's easier. Unlike before, we were going to count prayers. We are going to say yes, but we have to count prayers. We have to count annexures. So it's easier. It's predictable. It's predictable from the law firm side. Now, save for on these two aspects, save for annexures. If someone is having annexures of over exceeding 100 pages, that's when we're going to say for the first 100 pages will be deemed to be within the primary documents. But for the ones exceeding 100 pages, now will be paid for separately. So that's for the annexures. Annexures will be paid for separately. For those exceeding 100 pages, would attract another fee of 300. So so you can see in this aspect of a claim, both in the aspect of liquidated and unliquidated, you can see there's an aspect of consolidation, and it has been simplified. We are no longer using that formula that people were with that complex formula that led to an assessment. Now it's just that schedule, and it's a flat fee. I've also mentioned, maybe I can also mention of an aspect of defense. When someone is filing now a defense, now I'm saying the plaintiff has filed or the applicant. Now also let us also look at the aspect of a defendant or a respondent filing. So a respondent, when you're filing a defense, again, it's going to be a bundle. If you're filing a defense to a plaintiff, again, a fee is 500 for the statement of defense, for list of witnesses, for list of documents. This again is cutting across all court divisions and court ranks, as you're going to see down there. And type of application is 1,500. This is cutting across all the high court divisions, ELC, save for the lower court where they are paying 1,000. So it's very predictable. Application in the lower court is 1,000. Application in the high court and the courts of equal status is 1,500. So it's predictable. Bill of costs. This is now uniform across high court, lower court. This is uniform across high court, lower courts. So this has been standardized across all the court levels and the court divisions. That's what I'm to see now in the system. Now, having mentioned that, I want also to mention an aspect of petitions, and then we'll be able to move to another item. When someone is filing a petition, maybe constitutional petition, so those now are the unique things. A constitutional petition I think these have handled them. I want to see now a constitutional petition. Again, it's standardized. Let's say maybe let's start with these are the unique ones, like a judicial review. When someone is filing an application at a judicial review, you see that application again is 1,500 as it was before. But if someone is filing now, what you call now those the substantial motion in the judicial review, that's when you're filing that orders like orders for mandamus, certiorari, prohibition. Now is paying 10,575. This is when you are maybe filing the judicial review, or maybe you are filing the judicial review in ELC. Again, you can see the fee will be uniform. The fee will be uniform. Yes, so that's how when you are filing a judicial review, and when you are filing in response to applications. Response to applications is 750, and which is again across the court ranks and the court divisions. Court correction fee is 1,500. Again, this is also uniform across, even if you are filing, even if it's at the High Court or the lower court or ELC, is 1,500. So we have also moved from that percentage. We use now in the system before we had a percentage, 10%. In other places we have 5%. Now is 1,500. So again, this has also been simplified. A certificate of actions at the High Court level is 2,250 for all divisions, save for family division. Family division is going to charge a certificate of actions 1,500, but all other divisions of the High Court and the ELC is going to be 2,250. Maybe this is what I was moving to, a petition. Petitions again is going to be, when you're filing a constitutional petition, it's going to be 6,125. And a reply to a petition is going to be 1,500. Yeah, that's the unique item. I think now all these I write on them, because we're on now to see them in the system. Maybe another item I will also mention on, there is also a waiver of fees for children cases. That's another outstanding item in this new court fees regime, that when we are filing now new fees for children cases, all of them have been waived. So it's free. Either when you are preparing a plaint or a pleadings on children cases, either children in conflict with the law, all children in civil cases, all children in need of protection and care, now filing their fees is nil, has been zero rated. So that's another outstanding item that we can also be aware of as law firms. When you are now, that's so you can see this new fee regime is really very favorable to the LSK, to the advocates, or not to the litigants. Maybe it's an aspect of access to justice. Now we move to another outstanding item. Maybe I can bring attention to the advocates. We also have unchanging fees that are not changing, that are also remaining in the old regime. It's also good. We appreciate that others that remain in the old fee regime. One is Supreme Court is remaining in the old fee regime. The way you have been paying fee for the Supreme Court, it remains so. Court of Appeal is also remaining in the old fee regime. That's Court of Appeal. ELC, Employment and Labor Court, again, is also remaining in the old court fee regime. And tribunals, and the following tribunals, that's Cooperative Tribunal, Business Premises Tribunal, Rent Restriction Tribunal, High PT, Industrial Property Tribunal. They are remaining in the old fee regime. Though you have been doing before, with them, they were not changed. Again, for this is because their fees is legislated. There's an act of parliament that supports their fees. So the way you are doing their fees, assessment and payment are their own, it remains. So maybe another aspect I can mention on, and then we move to the practicals. So this I'm building for the practicals. So you see what is changing and what is. I want now to mention on aspect of what has been waived. Application to sue as a pauper now it's free. When you apply to sue as a pauper as an advocate, now it's free. And the application to reconstruct a file, now it's free. You can see it's nil. It's nil. Application to withdraw a suit is nil. You used to have fees here. Now, what we have also introduced again, when you request for a ruling, for a judgment or proceedings, it's going to be 1,000, only 1,000. So now this a new fee that has been, instead of, has been even, we can say it has been simplified. Before, counting of pages, we were saying certified and certified. Now whether you ask for certified or uncertified is 1,000. Now we have removed all those other confusing, those other aspects that were complicating this assessment. Now, whether you ask for certified and certified, as much as you have asked for a ruling or a judgment or a proceedings, you just pay 1,000. We don't even count pages. But if you say you want 1 page of the proceedings, then maybe that's the lower court, you pay 1,000. So that's a new item that has, maybe it has that the component of simplification that we have simplified. We don't count pages. Someone was saying, I want 1,000 pages. You see, you are paying a lot of, like now the proceedings. The proceedings can run to several pages. Now it's simple. We don't count those pages. Now we just say pay 1,000. There we go. So there we go. So I think I've done high-level highlights of these gazetted court fees. And I will, these court fees again is available in the judiciary website. So I would encourage you that you can visit the judiciary website and download these court fees. You can also have it in your file. At least you can say there is a change. There's a change. It has been simplified. It has been standardized, and it has so that there's uniformity across all court stations in the judiciary. So the technical team have incorporated the new fees to the system. I'll hand back to Mr. Karanja, who will also hand back to my other colleagues who are going now to do a demo of the system. But before I do that, I also want to mention a new aspect that we have also brought in the system is the aspect of leading questions. You're going to see, for those who have interacted, we have brought in the aspect of leading questions so that to minimize misfiling of cases and an assessment. So when you're trying to find the e-filing system, it's going to ask you, what are you filing for? What are you applying for? Are you having a certificate of urgence? Are you having an application? So this is essentially to enable the advocates, you have a rich user experience, or you have a better user experience, and we minimize misfiling and assessments. So that's another aspect that we have brought in the new regime. So I will take this chance to hand over to our leader, Mr. Josephat Karanja, who's also going to hand back to my other ICT officers to do a presentation. Thank you so much. Thank you so much for your time, and thank you so much for your attention. We look forward for the questions. Back to Mr. Karanja.
Thank you, Mr. Atuya, and for that presentation on the list, on the fee schedule. So I'll not add much. I've seen, and we are compiling the questions asked on the chat. Please continue asking. So I will invite my colleagues, the developers, Mr. Chelule and Neville. Then they'll take us through the actual demo on the system, how this has been implemented. So Chelule.
They could be muted. Maybe the secretariat could unmute them.
I see Neville has been unmuted.
Okay.
Maybe I can also be allowed to share my screen. Yeah, thanks a lot. So my name is Chelule Maina, software developer in the judiciary. So I really want to make a few addition to what my colleague has presented, and this and then I'll hand over to my colleague to do the e-filing. Though I'll also do a bit of demo on assessment for the internal users, because we have a few of our internal users. So we have been running the e-filing service within Nairobi, and we have learned quite a number of lessons. And one of the lessons is most of the users have been misfiling, so that you find someone who's supposed to file in the lower court, but they will file in the high court. So we have introduced the leading questions. I don't know whether I'm audible.
You are.
So these leading questions will now guide our users into filing into the correct division or into the correct station. The other thing that we have learned is our traditional fees were not harmonized, so that you will find various stations doing various assessment differently, so that the mode of assessment is different based on the station that you are filing. So we are trying to harmonize the process of filing and filing documents, and that led to the introduction of what we now call the bundles of documents. So a bundle of documents is basically separated into four or five categories, so that we have those documents that can only be filed by the initiators, that is the plaintiff, the appellants, those people who initiate a case and get a case number. The second category is those documents that can be filed by the defendants, respondents. They are only replying to an existing case. The other category is we have documents that cut across, that is, documents that can be filed by both. Maybe you have affidavits, list of documents, those one cuts across. Then we have the fourth category is the applications.
Chelule,
yes?
Please move closer to the mic. You are very faint.
Sorry for that. So let me just see whether, okay. I think I'm now clear. So I was talking about the bundles and the reason why we had to introduce bundles. These bundles now have been categorized into around 5 categories. The first category is documents filed by initiators. We have documents filed by those responding or filing defense. Then we have the third category, whereby documents that can be filed by either party, that is both plaintiff or initiators and the defense team. Then we have the fourth one, which caters for the application, that is the certificate of urgency and any other application that does not include certificates. Then the fifth category now is any other documents now. Any other document that was not factored in and maybe we require to file will now be placed under the general documents. And basically these one now are these documents that were initially charged 10 shillings, 75 shillings, but are no longer being charged. So all those documents have been bundled into one category, which I'll be demonstrating in a moment. The other addition that we have is what we call plaints and liquidated claim. So the liquidated claims have been categorized into 4 categories. We have the liquidated claim, whereby the person filing is sure of the amount of claim. The other one is the non-liquidated claim, whereby we are only charging 1,500 or 2,000, depending on the rank. Then we have a category of a plaint that is, we have introduced, it's called hybrid. They contain both the special damages and general damages together. So we have created a category that is called hybrid. The reason we created this is because towards the end of the case, we have to recalculate the fees and subtract or add and generate an invoice for the balance, because we will now depend on the amount awarded. The other option, the category is the amended plaint. So for the amended plaint, we had an issue, and this is the reason why we haven't introduced it currently, because when you are filing an amended claim, we need to capture the original value that you had, so that we check, is there a change in the monetary value of the plaint, so that we can calculate. But since the Gazette notice did not specify how we'll handle that, then we have introduced 1 or 2 inputs to help us now recalculate the figure. We'll see that. The other option now is the counterclaim that is meant for the defense team. So without further ado, let me try to demonstrate for the internal users, then my colleague Neville will come and do the e-filing. So under the CTS, the journey is just the same. So sometimes we have assessment, and you can do assessment with uploads or without uploads. So for now, I'll demonstrate, because I don't have any uploads. So we normally invoice parties specifically. So if a law firm is linked to a party, for us, we invoice the party, and then the details of the invoice, we normally pick the law firm. But if the law firm is not specified, so we default to the party. But if the law firm is if the party is linked to the law firm, then we normally invoice the law firm or the advocate. But on this case, whereby there is no advocate, we normally link an invoice direct to the party. And as you can see, we have categories of parties. We have plaintiff, defendants, and depending on what you select, that now will define the type of document that you will get. So I'll pick that, and then I will say, because this is an internal system, we also collect deposits, fines, and we also have those documents that emanate from the court. But for the purpose of our external users, we'll pick fees. And now we have the various stages of filing. So stage 1 is subsequent filing, and this one does not attract any figure. So if you pick this and file any documents within this category, within this, then you are not supposed to be charged, because we assume that you filed your previous plaint, and now you are coming to file subsequent documents that form the plaint. Yeah. So the other option, number 2 here, is meant for application, any person filing defense, response, or any memo. So the issue we had with this is someone would come, pick this filing application, and then pick any other type of application, and then pick this affidavit. So that means this person will be charged 1,500 shillings because of they picked the wrong category. Because the system will assume that you have an application and you are filing an affidavit, and you normally prepare this document, for example. Show you an example. So you normally add that, but because now this person is in a hurry to file an affidavit of service, he will just come without even uploading any application, submits this. So this affidavit will look as if someone was being charged 1,500, but in essence, the system assumes that we are charging that bundle, and that bundle will contain an application, will contain a certificate of urgency, will either contain a, sorry for that, will also contain a application, and all that bundle costs 1,500.
Telule, your voice is still faint. Maybe increase the volume of the mic.
Let me see. So how about now? Okay, so so the reason why you have some parties and law firm being charged 1,500 is because of this selection at this point. And this, I think, will answer one of the questions that was asked initially, why we are charging an affidavit 1,500. So basically, it's about training, and we had agreed that we are supposed to run a number of these webinars so that we can do the training and explain to our users how to do assessment, because the assessment now has changed. In fact, most of the people had not read the Gazette notice, and that is why they were wondering why. I saw someone being charged 330,000 for a plaint, and it is because of the wrong picking of the document. So having done that, we have also introduced what we call the general documents at this point. So the general documents will contain any other document that is supposed to be, that was not in the Gazette notice and form parts of the plaint, and we believe it's not supposed to be charged. So all this will appear under the general documents, and now we'll be able to file without being charged. So that is assessment internally. I want to invite my colleague Neville to do the e-filing, and then we'll come back for question and answers session. Neville.
Thank you. Thank you, Chelule.
So let me stop sharing and then I can share.
Yes. Okay, thank you. My name is Neville Masheti. I'm a software developer. I'll take you through the e-filing journey, that is filing a case and filing additional documents on a case. So let me just share my screen straight away. Okay. So you can be able to see my screen.
Yes, yes.
Okay, thank you.
Yes, we can.
So
We can.
Okay, thank you, Honorable Tanui. So I'll start the process. I've already logged in as a law firm. I think we are all familiar with this interface currently. It has not changed. So the process of filing a new case, I'll start filing a new case. So just to bring to attention, the process of filing is a bit different for the various court ranks. For Supreme Court, Court of Appeal, and the LRC, we are using the old process, the process as it were before for filing a new case, since it has not been affected with the new court fee schedule. But now for high courts and magistrate courts up to Kadhi, we're using the new, the gazetted fee schedule. So I'll use an example, a quick one, Milimani High Court. So with the Milimani High Court, you can see the options that I have for selection are a bit different because it is Milimani High Court based on the new fees. I'm going to use the questions to lead me up to determining the case that I want to file. So I have to pick the division. So I'll use commercial and tax. And then I proceed. So the moment I now start the filing process, the first question I need to answer is what I'm filing or applying for. We make it to be applying for, so in the event that you have any application, so it makes sense in that context. So I'll pick, I have various options that are, these answers will lead me now to a case if it is a liquidated claim, non-liquidated claim, and even the hybrid, as Chelule mentioned, that is a combination of liquidated and non-liquidated. So let me use an example of a liquidated claim so that you can be able to see. So the moment I pick, I respond that I want to file a liquidated claim, I'll be shown the documents that I'm expected to file in this bundle. So these are the documents that I'm expected to file when I'm filing a liquidated claim. The mandatory documents are the ones ticked. As you can see, there are some documents that are ticked. These are mandatory documents. You need to file these documents in order to proceed. But the documents that are not picked, these are the optional documents, so you can file them at any moment. But regardless of how many documents you file, you'll be charged the amount of the entire bundle. So for liquidated claim, you'll have to enter the value of the claim. If it was an unliquidated, I'll not be expected to enter the value of the claim. So, and the documents are also shown before. So the other question is, if I have any other application that I need to file, that is, it can be an application under certificate of urgency. This case I'm filing, if I want to file it under certificate of urgency, if there is no any other application, I can just pick none. So you can now see the amount that I'm supposed to pay. That is for the entire bundle, which is 2,000 for filing an unliquidated claim. And I can now have a view of what is the case type that I'm supposed to file. So let me go to the next step. So if I go next, the next step is now whereby I need to add the case parties. So I'll quickly add 2 case parties. It is mandatory you have an initiator and a respondent. So I'll use a plaintiff. I'm using state agencies because it's quicker. They're already configured in the system. Let's say the state, it is KRA. And then I'll add a respondent. So the respondents, it can be, let's say, an institution. You can add Kenya Pipeline. So another thing that you have to note here, probably people have been stuck at this moment where you are not able to upload documents. It is only the parties that are initiating a case that will be able to upload documents, because at this moment the respondent should not be able to upload a document because he's not the one filing the case. So it's only the initiating case party that will have this icon here. As you can see, for the first plaintiff, there are 3 icons. So this icon is now for uploading a document. So if I pick on this one, it will automatically be the Kenya Revenue Authority. Now I'll have all the documents within that bundle that I can now start filing. So let's say if I want to file a plaint, then I give it a caption the way I want it to be. I like to prefer to it. Then I choose from my computer. I proceed to uploads. Okay, now we have added that document. We can add as many documents as you want within that bundle, but the fee will be the same. So with that document, I can now go to the next step. The next step is where I now enter the case summary or prayers. This being an unliquidated, the value of the case is 0, and the citation is already generated for you. So you can just enter the case summary for the demo. I'll just do that. Then I go to the next step. So the next step here is where you confirm what you are filing. You confirm that all the details of your case are correct. And you can also be able to see the fee that has been assessed, which is 2,000 because of the entire bundle. I even just uploaded 1 document. Even if you upload 2 or 3, the fee will be the same because of the entire bundle. Then you submit. So the moment you submit, now your case is here in the dashboard without a case number because you have to pay for it. So if you come and view this case, you'll now be able to see an invoice has been generated. This is, you filed 1 file, the invoice is just 2,000. So at this moment, in case all my documents were not ready when I started filing this case, I can now also come here and file additional documents. So when I'm already within a case, and this is the tab of launching requests, there is a button here, file additional documents. So if I come here, I can now file additional documents. I'll just pick the party. If it is now Kenya Revenue Authority, I want to file a fees. So within that bundle of the non-liquidated plaints, maybe I forgot to file a verifying affidavit. So it is within the bundle. So I can still come here. Maybe it was not ready at that moment. I can now file it as a subsequent filing for existing matters, and it will not be charged, since when I was filing the entire, when I was filing the case, I already paid for this amount within the bundle. So if I pick this one, and let's say it was non-liquidated, and I want to file a verifying affidavit. So I pick verifying affidavit. I pick it from my machine. Then I upload. So just a moment, it's uploading. So as you can see here, the first document I filed, which was within the bundle, 2,000. Now for this second one that I filed, the verifying affidavit, it is 0 because it is a subsequent filing within that within the bundle. So the moment I pay 2,000, I've already paid for it. I'll not be able to. I'll not be required to pay for it again. So that is now for subsequent filing. So the other thing I want to indicate is the moment I want now to, the case has been filed, I've already paid for it. The payment process remains as it were before. It has not changed. The only change, what has only changed are the processes of filing. So the moment I've filed and I have a case number, and probably I've already served the respondent. For the respondents now to be able to file a response, okay, just the respondent being already linked to the case, he'll be able to come to the case, see the case summary, parties, activities, but now take note of the lodging request. Also, the respondent will now file additional document as a response. So the respondent, maybe it's this ESC, he wants to file. Now for him or her, you will select the filing of application, defense, or response. So for this one, it will be charged because it is now a respondent filing, and you will pick it now what you want to file. If it is a defense, if it is a bill of cost, now you'll pick the entire bundle that you want to file, then pick the documents that he wants to file, and now be able to file as a response. So as my colleague Chelule mentioned about the general documents, they are under this option here. That is a document that is not within any bundle, but is required before the court. For deposits and fine, we have this option here, but not yet activated. So that is the entire process of filing a case with the new bundles. So where there is much emphasis is just on this step here. Depending on what you have selected, you have various, the questions will lead you to a different case, and these questions will vary depending on what you're filing. In some cases, you'll realize there are different questions, so it is dynamic. So I think up to that moment, that is all with the filing process for the new fee bundle, for the new fee schedule. So I'll hand over to Karanja or Honorable Tanui or Chelule. We proceed with the program. Thank you.
Thank you, Masheti. We could also show for the courts which don't have e-filing, what happens in the registry.
Okay.
2 CTS, yes. The courts outside of Nairobi which don't have e-filing.
Okay.
Neville?
Yes.
You're using, I think you're using the wrong link. That's 4.1 or 4.
No, this is my local.
Okay. Noted.
Yes. So this is now the case tracking system, mainly used by the internal users of the judiciary. This is how it looks. So if I want to file a new case, and this is internally where there is no CTS, you have sent your documents or you have presented your documents before the registry, you'll start with register new case here. We just start on that one. So now for the internal users, you already mapped to a station, you already mapped to a division. So there is no selection of a division the only thing that you alerted that you are in this division of station, and now you now pick what you want to file, and you just be limited to this division of station. So if I want to file something, let's say in the custody and maintenance, this one, let me just pick that option. So I'll be presented with the documents that I need to file, the same process as it were on e-filing. Then I'll have a question if I want to file any other application that is under certificate of urgency. I can also pick that one. Then I go to the next step. So the next step here, you just need to add the case parties, and I'll show something that is different for this, for internal users, that may not be the same as the e-filing process. So for the case parties, every time I add a case party, for every case party, you specify. Let's say I want to add a respondent. Let me pick a respondent. Okay, let me just pick an institution. It is easier that way, even with asset recovery. So for the on the e-filing side, since it's the law firm that has logged in an individual, you automatically, the parties that you have are automatically linked to you as a law, to you as to the law firm. But now internally, when you're filing a case, now this is how they link the case party, the law firm to a party. So let's say I want to link, I'll just enter 2 letters, and I'll be able to search the entire law firms that are there. Let me see if I'll get okay, I think there is an issue here. But now that is how the law firm is added. I'll just check, maybe there is an issue on our local environment. So the moment I have the case parties, if I already added the law firm, will be added here. It will be automatically linked here. And the documents I add through this option, the same as e-filing. So if I go to the next step,
Neville,
yes.
Just increase the mic. Some people are saying they can't hear you.
Is it better right now?
Yeah.
Okay. So I was showing the filing of case internally. That is for parties that have presented before the registries. So we are at step 2, in case there is somebody who did not get clearly. So the steps are just the same as what you had on e-filing, but I'm just showing what might be different, paying attention to what might be different for internal users. So addition of case parties, the same process. The only thing that varies is you also add a legal representative to every party when you're adding. So, and this also the same way you had on the e-filing side, where you can add a file, you upload documents for every party through this option here. And this also you do it on the e-filing side, on the CTS side. So if I go to the next step, okay, sorry. Something I need to add, okay. Let me just use the test environment. I think I have an issue on this one. Chelule.
Yes, Neville.
Can I get please a sample login?
No, can you go back to the previous link? I think you have to upload at least one.
Yeah, I have an issue on that environment. That's why I want to use this one.
No, I'm saying,
Yes.
I think you have to attach at least one. Just go back to where you are. Let's get to the next step. Yes,
Yes, I have an issue there.
it's not adding.
Yeah, that's why I want to switch to the other environment. Let me just get a sample login, then I use on the other environments. Okay. Or perhaps use a different case type. Okay, fine. Okay now. So this was on the document upload. Sorry, I think I had an issue with the connection on our test server. So this now on adding the documents, I just try to add a sample document there. So if I can now be able to go to the next step. So that was a validation. In case I've not added any other document, I can now be able to proceed to the second step. So this step is just to add the value of the suit or the value of the case and any prayers. So this being an unliquidated case, so the value is 0, and maybe the case summary. So I'll just do anything for the case summary. Then I go to the next step. The next step is just confirmation, and then submit. Okay, so that is all the steps for filing a case internally as well as externally, as I had indicated the filing system. So you can, so this now the case, it has already been filed. You have the case but pending payments, you just need to pay for it as the other process. You have your invoice here. Now you can also be able to pay for the case. And for the subsequent filing is how Chelule had indicated when he started. So it is pretty the same as it is on e-filing. Thank you.
Thank you very much, Neville and Chelule. I will now hand over to Honorable Tanui so we can go to the question and answer session.
Thank you, Karanja, for leading that technical team. Neville, we almost thought you are also struggling the way we are, yet you are one of the brains behind this system. At least you got to redeem yourself. So there are a number of questions that we have right now. Chelule and Neville, we will want you to at least demonstrate some of the answers to the questions that have been asked, especially on filing of additional cases. Please don't go out of that page. But for now, let's just go through a number of questions. Some of them are policy questions, which I can answer. Some are technical, which I would wish the technical team to answer. And Mr. Karanja can also help with some. So Mr. Karanja, if I can go now to, I'll start with the last. Kindly advise on how to fix mention dates and hearing dates. Now we know that before 1st of September, we were paying 150 shillings for purposes of a mention date or a hearing date. Now all those fees have been dropped. You don't have to pay anymore for you to get a mention date. You don't have to pay anymore for you to get a hearing date. So proceed the way you have been doing in respect to fixing dates. Either different courts have adopted different ways. You do an email if you have to do an email. I know there was an issue with the automated process of taking a date. We hope that you will be done by next week so that we have that process automated. But for now, please proceed and just fix your dates, either by writing an email to the respective courts, and you will not be required to pay the 150 shillings that was being charged. I've lost the questions. Okay, then if subsequent filings have zero fees, it means there is no receipt. How do we prove documents have been filed while serving? Now we are having no receipts, especially for courts outside Nairobi. The only proof that you will have is the stamp and the date on the stamp. So the documents will be stamped for you, and the date will be affixed therein. Even as we look to having receipts which indicate a zero charge. And I would want Mr. Karanja or Mr. Chelule to talk about this. Are we looking forward to having receipts which indicates a zero charge very fast, so that we don't have question, I mean, a lot of time on that? Mr. Karanja,
no,
Mr. Chelule?
No, we'll not have receipts, but we'll have the invoice indicating zero charge, but receipts, no.
Okay. So going forward, how will people prove that they filed?
We'll use the invoice because there is no charge, so we cannot take it to account to give you a receipt for zero. But just the invoice and then it's stamped should suffice for now until we find a better proof of filing for those zero rated matters, working with the finance people.
Thank you. Linking also takes a while. Kindly advise. As of this morning today, we had a problem with the request that you had made for purposes of linking, but I can confirm now that the linking function is working. There was a slight update that was done at night, and that's cured the problem that we had as of yesterday. I know several courts were affected, especially the Milimani commercial courts, where they have big numbers in terms of requests, but as of this morning, I'm sure they've been working on the requests that have been pending. Kindly expound on filing as a state organization, and we'll go very fast on that.
Okay, filing as a state organization, number one, for all state agencies, since they are already known, we have to create the accounts from internally from the CTS side, because if it is KRA, we can only have one KRA. So they have to create, we have to get their details. So they just send their details through the email on the e-filing platform, and the accounts are created so that we only have a verified account for the state agency, so that we don't have so many fake accounts. Let's say we have so many fake accounts for AG, so many fake accounts for ODPP. So that's why it happens that way. So the accounts have to be created from our side. And now when they have the account, now when they log into the system, they can now also be able to file. And that is because of some of the benefits they have. For some state agencies, their fees are waived. And that's why it is controlled that way.
So thank you, Neville. I'm expected to make a deposit to court. It's a magistrate's court for proceeds that are in disputes in a case. It's been months since the court staff has not been able to generate the invoice to enable payments. Kindly shed light on how to deal. Chelule, on issue of deposits, or Neville, I remember you said it has not been activated, but you could speak to that. I'm expected to make a deposit to court for proceeds.
Yes, we normally generate deposits and cash bill internally because of issues of verification and approval. Sometimes we want, when a deposit is generated, it goes through various stages of approval so that you confirm that it is equivalent to what was supposed to be paid. That's why we haven't yet introduced it on the e-filing, but we are trying to also bring in the issue of generating deposits from the e-filing for the purpose of addressing these recurring payments, which include maintenance fees, decreto sum. Someone can do the assessment from their end, it goes through the normal process, and then we issue the invoice. But the invoice are currently working from the internal system.
Okay, thank you for that. So, so have you answered that question? So what do they need to do?
Yeah, it is supposed to be raised internally by the register staff at the moment.
So for that particular issue, please do an email or let the DR know so that we can be able to then raise an invoice from within for you to pay. Why are common documents like submissions and reply to defense missing from ELC? I don't know whether that dropped down now on general documents. Does it have a number of documents now?
Yes, it has most of the documents that were missing, and it's something that, that's Neville.
Yes. Can we see the documents that are there, whether you have addressed the issue of submissions, affidavit of service, requests for entry of judgment? There have been a number that have been raised. All the missing documents, notice of appointment.
Yes.
The documents?
Yes.
Yeah, we have most of them are there.
So why I'm asking them to show is because this became available this morning out of that slight update that was done to the system yesterday night. So we can be able to file all the documents that have been missing using this tab. Just go to the general documents tab and you can pick all the documents that you need to file from therein. We are still updating that tab so that we have all the documents. We have sent an Excel sheet to all the registries so that they can collect as many documents as possible that have been missed out. So that is work in progress, but we have started with the ones that had been highlighted through the various platforms that are that we use to collect. Mr. Can you proceed? I think. Yvonne, are you there?
Yes.
I saw a charge of 10,000. Yeah.
Hello?
Yes. I wanted you to pick up. I was having an.
Okay. So we can, I saw a charge of 10,000 for application of interlocutory judgment. Please explain. I would need to know the exact case, but unless there was a mismatch or the wrong, as the team has shown, someone selected the wrong option, then you get the charge for 10,000. But that you can just post the exact case, then we, the Then I successfully went through the process, but I got stuck at the payment stage. Yes.
The 10,000, it has been an issue. We know that there's been an issue of an invoice, a flat invoice of 10,000 shillings. Maybe the technical team can tell us what happened. I know that was done yesterday. A cure was done yesterday. You remember? There've been a number of invoices which generate 10,000 shillings.
Yes, this was basically the wrong option which they pick when they are doing assessment for the hybrid version of the plane. There was the wrong formula, and it was configured, which we have removed, and is currently not there. So we have fixed the issue. So all the invoices that have been generated so far and attracted 10,000, we have to regenerate again and give the correct invoice. I hope I have answered.
Yes, you have answered. Mr. Karanja, now take over. My phone is dying. I was using my bundles. Please take over.
Okay, sorry, it was still muted there. The question was, why does it take forever to get a response from the court, especially when information is sought through email? Often emails are not responded to. We agree this has been a challenge, and we are trying to change. The challenge has been the number of emails sometimes received, especially for commercial court. The number of emails have been quite overwhelming, but I know the court is making, putting in place measures to just see how the answers, how we respond to emails faster. There was also a case around the same thing, that the virtual link we provided also, you kept waiting for long, but we're trying to improve with increasing the number of people who can support, because again, we are receiving on a day basis very many people. As I said, the last 16 days have been a learning experience. So some of the people who went through the first days, you had many challenges. Example, some people have raised the issue of their case numbers. The case numbers changed during filing, especially late last week. So it's an issue we've noted, and we're going to correct, and then we'll communicate to all the affected parties about the case numbers. We've seen kindly assist linking. Yeah, the issue of linking, Honorable Tanui had said we had a problem with the system. So for the last 1 week, linking was a bit difficult, linking cases and parties, but this has been resolved. So we will, the ones which are raised here, will forward to the family division. We have seen 2 from ELC, so they can assist. So what happens when an invoice is not generated, even after selecting the correct option? We had challenges with invoices today. So in the morning, people could not generate invoices, but we fixed this in the afternoon. So we are going to run those, we'll run again, just run the item again, and then now you'll be able to get an invoice. For those who are not able to get invoices in the morning. We've compiled, now we are headed to close to 100 items. We may not respond to all of them now, but we promise we'll compile the complete list and then share it with the Secretariat, that all, to make sure all the questions are answered to. Then there's another one, with certified copies of grants in the family division attract charges. Mr. Atuya, you can answer that.
I can help Mr. Atuya on that, Mr. Karanja.
You're back online? Okay.
Yes, the fee schedule does not give us any provision for charging for certification. So we are still waiting for advice on how to go about it. But for now, we have no reason to charge for certification. unless you are filing at the Cadiz Court, because the only charge that has been given is at the Cadiz Court, which gives a standard figure of 100 shillings.
Why is the system, thank you, Ms. Onabotanu, why is the system currently inaccessible? We've noted earlier in the afternoon, and the team is looking to get the system back online. We have been unable to file a succession matter as the Catholic Court. After the case parties, we are told to upload the document, yet there is no tab. So we are unable to proceed to step 3. We'd like a demo. And Neville, you can do a quick demo for Catholic Court, filing of succession matters. And unfortunately, there is no sound.
Okay, sorry. So there was an issue.
Maybe you can start.
Sound.
That the person is there.
So that's just filing a new case. Kadi. So it is a succession matter. So I'll just add any party of type. So if it is the petitioner, okay, let me use individual. It's more relevant to this one. Okay, this I used a phone number that already exists. So I can, if this party already exists, I can just click here to add the party directly, or even change the phone number. So for the documents, the party that you need to add should be an initiator, as I emphasized in the first presentation. So like this petitioner is the only one that will get this option to upload documents here. So if I click on this one, I select the document, application for grant, then, need to choose a file. Okay, let me just pick that one. Okay, so that's how you upload the documents. Then here, for succession cases, so after having the summary, case summary, for succession cases, you have to add the details of the deceased, which are mandatory because they will be critical in preparation of Form 30 or gazettement. So place of death, death certificate, value of the estate, and residence. Then you proceed to the next step. Oh, citation. So in the estate of Mzee, they say that way. Okay, I note there is a bug then for succession here. If this was the case, then I think this one you're going to fix it. It is something that we should fix in the live environment on the details of the case. I know I'm noticing there is a bug here where all the details, even if you have supplied the details, is still inquires for you to enter the details. So this is something we shall note, and we shall have it updated.
Thank you, Nabil. That is noted. We'll note it and have the update done. Then on page 16, under the Magistrate Court Criminal Cases Part 4, this fees for hearing after the first hearing, where does it apply, to the advocates or to the litigants or both? So I'll request Honorable Tanui to assist. Or Atuya?
Yes, I'm having that for the hearings in the criminal case. We had that one, and we did raise it up with the committee that fee, the one that was given under the criminal court. I'm trying to get it. Sorry. Where it charges fee for a hearing after next 1,000 shillings. So the question that we posed to that committee is, who is supposed to make payments, and where do we, who generates the invoice in the first place, and to who is supposed to make that payment. So for us, even when we were doing the configuration in the system, if you will see that we haven't activated it because it didn't also make sense to us. It does provide that hearings after the first hearing for each day or part thereof is 1,000 shillings. So that when you do a hearing in the criminal court, if you have to adjourn it, then for the next hearing date, before the next hearing date, somebody has to pay 1,000 shillings. It didn't make sense to us, and I don't think it also makes sense to anybody. For us, we did raise it to the committee, and we made a recommendation that it be scrapped. So it shouldn't, I don't think it should disturb any of us for now.
Okay. I've tried to do assessment, but every time I go to ELC registry, I'm told the system is slow. Can you address this issue? So Chirume would want to know more details about this case, maybe the case, and then we can address it. Is it maybe the case number? Just share with us the case number, Chirume. We'll be able to address that. I kindly address the issue of missing cases in the portal. Thanks. Again, I would want this one to get exact case. As I said, there was an instance last week where some things changed, some case numbers changed. So, and we are addressing that. But for missing cases, please share with us the number if you have of your case which is missing. Then we'll be, even right now, then we can check. Yes, e-filing is not working at the moment. Yes, we have a challenge. This afternoon it's not working, but we have a team getting it back online. How do you add case parties details, e.g. the defendants whom you don't have details such as email addresses and phone numbers and even ID numbers? Chelule, when you're doing e-service, you can comment on this.
Yes, the reason we are collecting this information, the email address and the phone number, is because we are doing what we call notification. We do send notification to parties who have no advocates or who have no law firms, or whereby a law firm has dropped. So we need to continue to send communication to the parties, especially when there's a date that has been set in court or where any activity has happened. Maybe the defendant has filed some documents. We need to notify the other parties. And that's the reason why we request for this information. Why are we making them mandatory? We are making this mandatory because most of the cases that we have in the judiciary and which we are unable to proceed are those cases whereby we are unable to reach any of the party, law firm, or anybody within that case. So you find that there are very many adjournments which affect the backlog, and that's why we have decided at least we need to collect these details for the purpose of disseminating those critical information. Thank you. I hope I've answered that.
Okay, thank you. Why can't we go back to the earlier system? This system is complicated. We take the feedback, but as we have said, this has been occasioned by the change of court fees and the bundling of documents into one fee applying for a number of documents. But I'm sure with time, with more internal stakeholder engagement, external stakeholder engagement, we'll all be able to get to a point where we are comfortable with the system. Then there is no divorce registration cost while filing a new case. I think Honorable Tanui has addressed this issue, that a number of documents are missing, and we are working to the registries and our assessors to build the number of documents available so that we reduce the number of missing documents. How about filing for request for interlocutory judgment? The only tab available is for copy of judgments and rulings, which are two distinct applications. So I will ask Honorable Tanui to answer that.
Mr. Karanja, that one is there. I did see it. It is one of the updates that was done yesterday night. So if Neville can just show us under the additional documents, one of it is submissions. The other one is interlocutory judgment, which should ordinarily now attract a zero fee. Sorry, I'm seated. My office is next to a construction site. There's a lot of construction happening now. So Neville, if you can show us those additional documents. One of them is submissions, request for interlocutory judgment, and then also affidavit of service, which I have seen under the bundle subsequent filings, because it's supposed to be a subsequent filing. Submissions. Affidavit of service. Okay, go to the general documents if they're not here.
Affidavit of service there.
Yes. And request for judgments. Request for interlocutory judgment. There it is.
Yes.
Yeah. So it is a pleading which is given birth to by the plaintiff. So we are not charging. So it's a zero charge for request for interlocutory judgment. What about submissions? Did I see submissions?
Okay, let me check.
There it is.
Yes.
So those I think those ones are now there.
Okay.
Mr. Karanja?
I filed an ad litem using a death certificate, but I'm unable to file letters of administration intestate using the same death certificate because the system responds that the serial number has been filed and another case number. Kindly advise on the way forward. Neville, we can check that.
Yes.
And you can respond to this.
Yeah, I can respond to that one. So for any P&A case, we try to prevent filing of multiple cases for a specific deceased person. So you try to validate the death certificate number. So in the event a death certificate number has already been used to file a succession case, you can't file any other matter in any other court unless if you want to be added as a party to the already existing case. So that is something that you can't file any other case using the same death certificate number that already an existing case has been filed for. So if it happens there is a case has been transferred or there is an issue, maybe the only thing can be you reach out to the registry and they have the case that maybe has been transferred to be closed, to be archived so that any other case can be filed using that death certificate number.
Okay.
Mr. Karanja, there's a concern about the window that Neville has shown us. Are you using the live environment? Because people are saying that the window that you have just shown is not available on their ends.
Okay, I'm not using the live environment. I'm using our test environment.
But is it live? The window that you have shown, is it on the live system?
Yeah, it should be. It should go with the update that we did yesterday, yesterday night. So probably I can just confirm if our system is back. So let me pick, I can even pick this one. This is on the live environment.
Yeah.
Okay, let me get a commercial case. That will be better. Okay, for these case types, it not be there, but we shall just, I think I'll follow up and see if it has been configured for all the case types on the live environment.
Those are in respect to the documents we have mentioned.
Yes, for this case type that I have already on the live environment, I'm not seeing those documents other than the bundles.
Okay, just ensure that that is done so that even by the end of day today, what we have presented is actually what is on the ground, isn't it?
Okay.
Mr. Karanja, please proceed.
Yeah, there is no divorce registration cost while filing a new case. And Neville, we can check that quickly.
Okay. That is in High Court family.
This is magistrate.
Magistrates, okay.
Yeah.
Not children.
Then, Chelula, you can prepare to show how to assess further court fees.
Divorce is there.
Okay.
Divorce and separation, that is Milimani Commercial Magistrate. Then the division is Magistrate Court Commercial.
Okay. Divorce registration. So Chelule can show us assessment of other court fees, and then Honorable Tanui will explain the issue of further claim. So Chelule, further court fees.
As it prepares, Mr. Karanja, what was the question on further claim? I'm trying to see.
Someone was asking, they want we explain how to handle up. I think they have just said claim, explain the issue of other of counterclaim. I think it's just how the person will go through.
Okay, so for the issue of the counterclaim, I will also take it up with the issue of amended plaints, which changes the value to a higher value. So as we are talking now, I know that is under development. So the issue now is when you come to file, we have to raise internally a further court fee, a debit note for you. For now, you cannot file and you can only upload your document, but we will then need to raise for you a debit note, a further court fee, so that you pay. But from next week, that process, the journey that a counterclaim, the journey that an amended plaint, an amended summon text will have been automated.
Thank you. Then there's a further question. Chelule, the issue of further court fees. How to assess further court fees? Or Neville? Chelule is offline. And your mic is muted.
So I'll do a brief demonstration of further court fees. So I love just to search a case. Let me use the test environment. So. Yes, it's a test environment.
Mr. Karanja, Neville is trying which issue because of time?
Further court fees.
Okay. In the meantime, we can tackle the other questions, and then the rest of the questions, I'm sure we can tackle them with time so that we don't keep all of us here. There are issues which I know we need to update tonight, especially on additional documents. So the earlier we are done, then the better.
So we've handled the issue of there's a question when you have filing pleadings, do you need to scan them as one document as opposed to the former method when we're uploading each document separately? The former method still applies when you are scanning. The only thing we are saying that the system will charge you as a bundle, but you will still be expected to scan and upload each document as we have previously been doing. Got assessed about 8,000 for submission, supplementary affidavit, reply to defense and list of authorities. I'm stuck, please resolve and assess the correct amount. Please share with us the details of this case, because as we said, it could be the challenge of selecting the options, which then results but Honorable Tanui, want to add something?
I think you have covered it. That is on filing, whether or not to scan and upload separately. Yes. Was that the question? You have answered it. We are remaining with what was. We are not changing.
We're not changing, yes.
Yes.
Then the system is not ready for use. Kindly allow for backup manual filing. Backup manual filing is work in progress, as we sent an internal guideline on how to do this, but we are still finalizing so that we can actually be able to use it, so that we're able to address all the issues raised when we tried to use it previously. But by the end of this month, we'll have given further guidelines on how to do manual filing when the system is not available. On Abotanui, there was a question of someone who was assessed 8,000 for submission, supplementary affidavit, reply to defense and list of authorities. So I'd advise we could get the particulars of the case and then we address it. But
yes, what we are going to do, Mr. Karanja, once we fine-tune the system, and I'm sure by next week it will have been fine-tuned, we'll send notice that anybody who was overcharged during this period, this transition period, then we are going to have a refund process. But we want to just be sure that the system is stable, and then we will start that exercise. So we'll collect data internally, and then we will also send out a notice to advocates, to those who are overcharged because of this transition period. We know some people have paid a lot of money, which they shouldn't have paid, and we will ensure that they are refunded. It's just going to take a while, but we will do that. Thank you.
Okay. We note Mituga, we note the case for ELC 287 from Mombasa. We're going to follow up on that. Mapping an advocate, a new advocate when another one has taken over a matter. We have a challenge with this. There was a bug on the system whereby you map the new advocates, but it's still reflecting the old one. So this is one of the issues we have packed for addressing within the week. And in our next update, it will be resolved. Are the excess payment made pursuant to erroneous invoices? Reflecting filing, I think on Abotanui has addressed this. We are going to handle it once the system is stable. Anybody who was overcharged, those cases will be addressed. Then we shed light on cases which are marked as closed in the portal and which can never be handled by the law firm. Are there parallel accounts, or how did this come about? Chelule, you can shed light on this.
I think that's a registry function, Mr. Karanja. What we are doing, several registries now and divisions are doing an audit exercise, so that when we find that a matter had been closed already, either by consent or even through a judicial process, you got a judgment, you got a ruling, what we are doing is we are closing those matters in the system, irrespective of whether or not we have notified the law firm. Because we are thinking, we have, yes, mapped it to you, but it is a closed matter, so that it doesn't reflect as a pending case with us. But we allow law firms to come, we allow advocates to raise issues if they have to, or if they need to file subsequent, maybe they are at the execution process, we allow you to open up the case and proceed. So that has been what has been happening, especially during this August vacation, where we did a lot of audits and closure and activating of cases.
Okay. I paid 2,000 for submission and was told that it was not correct payment. Can I get the refund? I think we've addressed the issue of our payments. How about warrant of attachment? I'm not clear about the issue, but is it that it's missing? This one is not clear. Person has just asked how about
Let me answer that. The warrant of attachment is any application. It is if it is at the Chief Magistrate's Court, it is categorized as any other application, which is attracting a charge of 750 shillings. We will need to just get to know whether they have been configured across the case types.
All the cases, okay.
Yeah.
So the other questions also on Abotanui about summons to enter appearance, they still treated the same as just any other application.
No, summons to enter appearance is bundled in the bundle for the plaints, so that if you have made payment for your plaint, whether liquidated or unliquidated or unregistered.
Okay. We note this has been highlighted that what we are showing is not what is on the e-filing system, especially on the list of documents, and we will update that. We have the same.
Get the summon without having to pay for it. Mr. Karanja, I missed that, sorry. Come again.
Now saying we have addressed the issue of the portals are not the same, what we are demoing and what is on live. So we'll ensure the documents are updated, the documents which are missing on the live system, and so that it reflects, especially the submission and the affidavit and the affidavits which are missing.
Yes. Yes, that is
not-
true. Because of the update that was going on, Mr. Karanja, you might, it might be. Okay, I'm not a technical person, but I'm thinking it's still work in progress, isn't it?
Yes.
So that even as you're updating the system, maybe by tomorrow, what is on the test environment should be now live by tomorrow.
Okay.
Yes.
Then just back to you on Botany, there is a question how to handle an amended plaint, amended defense, and the issue of summons. I think you had addressed this earlier, but it has come up again.
Yes, I've addressed it. The issue of amended plaints, even counterclaims, I have said that the system as of now is unable to calculate the further court fees. So we are doing it through a manual process. We are giving you the debit notes, but we will allow you to file the amended plaints. We will allow you to file the counterclaim. It is one of those documents that we just need to update, but we will then calculate it internally and raise further court fees for you to pay until we have their journeys automated in the system.
Okay. Then there is civil registries, civil magistrate court. The invoices are showing wrong amounts and giving case numbers before invoices are being paid. This is an issue we have picked and is being addressed, especially because especially where people are not paying documents which are free, or like the children's cases where you're not paying, where we're just going and giving numbers immediately, but then the parties subsequently don't want to move forward to the case or don't even come back. Maybe they were just checking the assessment. So we are addressing this and we'll revert back that invoices will only be, case numbers will only be issued after payment. So that will be addressed in our subsequent update. There was a request which we were to test with the cases without e-filing, and this is, Neville showed this using CTS. For those who are filing through email or bringing soft documents to where you don't have e-filing, so the registry is able to file through the case tracking system following the same process as highlighted by Neville. I think there is a question here. Hope all the categories of cases have been updated now. There is a tendency where documents pop up in some matters but can't be found in others. So Honorable Tanui has mentioned this, that we are trying to comprehensively get a list of all the documents related to each case, and we ensure that they are configured to the system. There are still gaps here and there, but the feedback we've received from both internal registry staff and also from the advocates, we are working to just make sure that list is as comprehensive as possible, especially where you have missing documents in particular cases. I think that we have addressed. So there's a request that we should not be running the test only with Milimani. We can use other cases, especially out of Nairobi. We've addressed the issue of divorce registration, Kathy's, that we have demonstrated. Then for an unliquidated claim, an affidavit of service will cost 2K every time you are filing the same. I think that was feedback. Someone paid cash bail for an inmate, but up to today, there is no receipt to enable him get the suspect from remand. How do we go about it? Please provide the case, LJ Oteno, provide if it was paid, there must be, provide the details of the case. There must have been a payment invoice, then we will be able to follow up. Even the payment number from M-Pesa or whatever was used, just for the details you have, then we'll assist with this case of someone who is still in remand since yesterday. I think we are starting to see the questions repeating. So Honorable Tanui, I would suggest we, as you said, we collect these questions, then compile the answers, and then subsequently share it through the Secretariat. Back to you, Honorable Tanui.
Yes, thank you, Mr. Karanja, with your technical team. Thank you, Neville. Thank you, Mr. Chelule. This we wanted, even if it is not as exhaustive, we will proceed with this kind of webinars. We can have it weekly for now. We know the system is still under development. We are still doing a lot of configuration. And team, both advocates and of course the judiciary staff who are still on call, we have a very lean ICT directorate and our developers are few. So sometimes it takes a long time to do these configurations, and our journeys, the journeys that the different documents, the different codes take, even case types, are many, there are various. We know, like, for instance, in the commercial codes,
Sorry, on Abotanui, I think we seem to have lost on Abotanui. Honorable Tanui seems to have a challenge, but I would request the chair. Would hand over back to the chair. You are back on Honorable Tanui.
Yes, I'm back. Sorry. Yeah, so I was saying that we sincerely appreciate your team, Mr. Karanja. We know how much it has taken to reach where we are, and we know that at least by the end of next week, we should be able to have stabilized the system, and with a lot of users taking, the uptake going high, we will stabilize it, and we will ensure that, where we were before 1st of September is where we will be. We had stabilized, and we know that we were all enjoying the use of the system, both external and internal users. So thank you very much for joining us. I now want to hand it over to LSK. Ms. Namisi, I know you are waiting to give us your closing remarks. Please proceed.
Thank you very much, Honorable Tanui. My name is Helen Namisi, and I am the Vice Chair of the Nairobi branch. Unfortunately, our chair, Eric Theory, is unable to make closing remarks because he has a very unstable network. And so I'm going to make closing remarks on his behalf and on behalf of the LSK Nairobi branch and the Branch Chairs Caucus. First, we start by thanking you, Honorable Tanui, for organizing and sharing this very insightful webinar. We appreciate and understand that technology is here to stay, and it's very important for us practitioners to keep abreast with the changes that affect our practice. And we are very delighted to work hand in hand with the judiciary because we realize and appreciate that this system betters our practice and also ensures access to justice for our clients and for Wanjiko in general. We also thank Mr. Atuya for taking us through the new court fee schedule, which I know was mind-boggling to a lot of us before he took us through this, and now it's become clearer. And from what I can see, it is also cheaper for Wanjiko in the long run. We'd like to thank the ICT Directorate, which Honorable Tanui has said is very lean. So we appreciate the efforts that you're making, and appreciate the job that you have done in helping us to navigate this system today. We thank you, Mr. Karanja, Neville, and Chelule. Thank you very much. We also will collate these questions that are in the chat section, as was mentioned by one of the speakers. And we hope that these questions will be addressed by the ICT team. Once they are, we are going to ensure that we circulate the responses to practitioners so that you're able to keep abreast with the answers and also try out the system. Let us know where you still are facing challenges, and we'll communicate the same to the ICT system. So ladies and gentlemen, this is definitely not the last training, as you heard the speakers say, and Honorable Tanui has also indicated that it will be on a weekly basis until when we stabilize and we're able to enjoy the system as we did at the beginning of September. And so we expect that you will also be able to join us in subsequent trainings, ensure that all your colleagues are able to join us so that we can all move together in this journey of ensuring that our practice is better, it is easier, it is efficient, it is innovative. And with that, I'd like to thank the participants for joining us today. We were at capacity. In fact, at some point I dropped off and couldn't come back because we were at capacity. Thank you very much for making time today. Please spread the word to your colleagues, ask them to join in subsequent sessions so that we can all walk together in this journey. Thank you very much to everybody who made time this afternoon, and most especially to the judiciary. We continue to support your efforts to make our work easier also. With those remarks, asanteni sana, do have a lovely evening.
Thank you.
Thank you, Madam Namisi.